This courtroom session starts off like any other, but within minutes, it spirals into a tense showdown between a judge and a defendant whose past may be too heavy to ignore. We're talking about multiple felonies, disputed restitution, and a plea deal that's hanging by a thread. But here's the twist. Just when it seems like she might walk away with probation, one decision changes everything. And trust me, what happens next? You won, TC coming.
Mr. Lewis, you have Crystal Vogan, this is sentencing. Good morning. This is Mr. Hoffpower's sentencing. I didn't see you over there, Mr. Hoffpower.
No, I did.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history we understand, Your Honor, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I haven't done nothing. I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of
Yes,
criminal
ma'am.
history?
Yes, deferred. Yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, Your Honor, I think that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was,
was 400 that was within the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSI, I told them I was notified if I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor, that's just one that was, that's the charge. I'm not coaching over there. But she's responsible.
Yeah. So I mean, if there was another person, and you didn't give that
I
information,
don't
then
know.
that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one called. Size, whether or not she had a comfortable. The backside, not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern, the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm gonna do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm gonna find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
This is probably the last thing anyone wants to hear from a judge reviewing a plea deal. While judges are meant to be impartial, they do have the final authority to decide whether a plea agreement serves the interests of justice. In this case, the judge isn't necessarily opposed to Karen receiving probation. Her concern is with the kind of probation being offered. The deal on the table was deferred adjudication, which differs from standard probation in one major way. If Karen completes it successfully, she can ask the court to wipe the conviction off her record entirely. This right here is the turning point of the entire case. The judge isn't just reviewing numbers, she's weighing patterns. And when you hear 14 prior felonies, that's not just history, that's a red flag in the eyes of the court. Deferred adjudication might sound like a second chance, but legally, it's a privilege, not a guarantee. The judge is signaling loud and clear. This isn't someone she trusts to walk away without a conviction on record. And let's talk about accountability, because even though the defendant tries to downplay involvement in parts of the theft, the law doesn't always separate actions when people act together. So here's the question for you. Do you think the judge is being too harsh, or is this exactly how repeat offenses should be handled? Given her prior criminal history, the judge isn't willing to leave that door open.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you do.
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases. That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
I know, double negatives from the bench are never fun to untangle. Either way, that wraps up that hearing. It does make you wonder whether her employer will hold her position while she works on pulling together $25,000 for bail. Next, we're heading to Florida, where I've been keeping a close eye on a case with several hearings worth walking through.
Your Honor, call Mr. McCoy's case.
Mr. McCoy?
Our conversations have concluded.
Mr. McCoy's here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time, these proceedings, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request that my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
Because you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up the fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker, but however you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case. Sir.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and then I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. Okay, what about, I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir. That's what Mr. Frank Sullivan. It's not looking for help. All the thing I'm asking, sir, is why am I been denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case,
Okay.
and they will only be an assistant.
I've heard this argument for the last, ever since you've been arrested, so it's already part of the record. I've already made my ruling. You've already appealed that ruling, so we'll see what the first DCA says. I'm gonna set this for a pretrial June 19th at 9 o'clock. That'll conclude the hearing. Okay?
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Ms. Clark, man, we got.
What do you want to put on the record? I'm gonna give you a minute. Go.
All right. Whole thing I want to put on the record, Ms. Clark, is I don't know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case. Why they still filing motions
Mr.
against me?
McCoy, I understand that argument.
But it makes no sense because it seems like my case is going nowhere,
Listen,
especially when you have nothing to even
These
try
state
to do.
attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
You know, he just said he does.
Huh?
He just said he did.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief.
I
didn't say I had anything to do with moving prosecutors or changing.
He doesn't move property. He is the division chief, so.
Okay, if
Request.
my old prosecutors ought to move to a different division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Basper. It doesn't matter who signs it, who files it. They were filing on behalf of Larry Basper. So that's going to conclude today's hearing.
That makes no
Go ahead,
sense, Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that.
This is State of Florida versus Devontae McCoy, case number 24 CF 2543 and 24 CF 2544. Mr. McCoy has made the decision to represent himself. Mr. McCoy, do you wish to continue to represent yourself?
Yes, sir.
We're set for a pretrial today. Where are we at?
I filed a few motions, Your Honor.
I've denied the motion to set bail. I've denied the motion to quash order to revoke bond.
Okay, Your Honor, can the state at least, or can somebody at least explain to me why I deserve to be held without bond?
No, sir. I've already done that, and I've already made the decision. You're being held without bond because you were arrested on a new charge and you pled to that charge. And I've already discussed that. So we're not going to have any more discussion on that.
Well, Your Honor, I would like to state for the record, due to the fact that, you know, it's on record and also by the person that actually committed that crime that day.
I've already heard that argument that you were making.
Clark,
Listen to me. I've heard the argument that you were a peacemaker, but you pled to that charge. We're not hearing anything else about setting a bond or anything else.
I never pled
What else
guilty
do we need
that
to address
charge,
today?
Well, I put in a motion to dismiss the information due to double jeopardy clause.
All right, that will be denied, but I'll get you a written order.
Well,
anything else?
can I, wait a minute, Your Honor, I need to state something for the record. I mean, I'm trying to understand why is my motion being denied without being heard.
I'm gonna
Not
get you a
hearing
written
my
order.
motion, Your Honor.
Anything else besides?
Yes, I'm trying to get my motion heard. I want my motion to be heard, Your Honor. I want to speak.
I'm gonna review it first because I'm gonna get you an order. I'm gonna get you an order, and if you want to do a motion for rehearing, you can do that. What else we need to do today?
I want my motion heard, Your Honor. I want to speak.
What else we need to do today?
I'm going to speak on my motion, Your Honor.
All right, let's go ahead and set it for trial. We're gonna set it for trial October the.
Are you setting for trial? I'm trying to discuss something with the state, Mr. Clark.
You have time to negotiate between now and then, October 6th, and we'll set it for a trial management August 21st at 9 o'clock.
Wait a minute. Also, what about
Your Honor.
that's not my last motion. That's not my last
Mr.
motion.
McCoy, that's all we're gonna take up today.
What about my motion for by my evidence, Your Honor?
I've already denied that.
Motion to preserve evidence. How can you deny a motion to preserve evidence?
I'll look at that. I haven't seen that yet. It's filed, but I have not seen it. That'll conclude today's hearing, Mr. McCoy. We'll see you.
I filed that a month ago.
Yes, sir. Mr. McCoy, it wasn't sent to me, so that'll conclude the hearing.
So you sending me for trial?
That will conclude the hearing.
Wait a minute.
Y'all take him out.
Listen, man, it's crazy. Though.
Take him out. Go ahead and y'all get him.
I'm gonna ask you to disqualify yourself from my case.
All right, well, we'll take it up the written order. Mr. McCoy, go ahead and take him out, Brian.
It never gets old, watching someone convince themselves that catching a few episodes of a courtroom TV show makes them ready to handle their own criminal defense. Spoiler, it rarely ends well for them. Now, let's move on to the next hearing in this case.
Mr. McCoy is before the court today, pro se. Mr. McCoy, you wish to remain pro se, is that correct?
Yes, sir.
Okay. See, I know you've got some stuff filed at first BCA, and also you had something transferred by me to federal court. You got that order?
Federal court.
Yeah, it was a pro se petition for writ of habeas corpus under 28 USC. That was transferred to federal court to allow you to litigate that there. Mr. McCoy, come on up.
Himself and others.
Yeah. Well, if this is state of Florida versus Devontae McCoy, 24 CF 2543, 24 CF 2544. Mr. McCoy is before the court pro se. Mr. McCoy, you understand at any point in time, you can ask an attorney to be appointed to represent you, and one will be appointed to represent you at no charge. You understand?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
We're set for a trial management today, is that correct? All right. Mr. McCoy?
I was coming to address a couple of motions that I have filed, which was Richardson here, based on the evidence that was destroyed that I was requesting over this year period.
Okay, what evidence is that?
Same one that we've had this hearing 5 times on, Judge. The video from the Sefco gas station that doesn't exist.
And the body cam from the FHP and the body cam from the Bay County SID.
The dash cam from FHP has been provided to Mr. McCoy. I handed him the disc in court personally.
So that's not the initial. I need the body cam from the Bay County SID because the FHP was only assistant Bay County.
Judge, sorry, you can finish.
You can go if you got something to say.
Judge, we've had this hearing 5 times already.
Okay, I understand that. I'm just addressing that, Mr. Frank Sullivan, because without this evidence, that's prejudiced me in preparing for my trial.
Okay, what evidence don't you have?
It's the exculpatory evidence. The video request, I filed like 7 motions.
So what video?
The video from the Sefco gas station.
Okay, that I've already ruled on that.
Well, and why is that? That's exculpatory evidence. I need that in order to defend myself.
You couldn't get it, and they didn't get it. They don't have to go get evidence if they don't have it. I've already ruled on that. It's part of the record, and it's ad nauseum part of the record. Okay.
Just saying this for the record.
Let me just make for the record. You're asking for video evidence that may or may not exist from a store that had a store that was part of this incident that may or may not have a video camera, correct?
100% had a video. I talked to the manager. She saved it in backup data.
Did you ask for it?
I did.
Okay, did you get it?
You need a court order and you denied it, Mr. Clark.
Okay, all right. Well, that's already been ordered on. That's part of the record. So you can do anything else with that. So I'm gonna deny that motion. So where are we at? You also said, Cam, you've got VHP tape, right?
That's not enough. That's not what I need.
I understand that. But I'm just asking you.
Exculpatory and impeachment evidence has been destroyed that I needed, so okay, I cannot properly defend myself.
I've already denied that motion.
How would you defend me?
What else are you asking for?
My evidence to defend myself.
What else are you asking for? I've already ruled on that evidence from the store.
Why would you deny me all the evidence? The body cam, dash cam. Why would you do?
Their body. That's what I'm asking. What about the body?
Bay County SID. Bay County body cam. The body cam from FHP.
Well, you've got the FHP.
No, you just got one dash cam. That's not enough. I need the evidence to prove what I was trying to prove as far as my innocence.
All right, Mr. Sullivan.
Exculpatory and impeachment evidence. I need that, Mr. Clark. I can't proceed and have a fair trial without this evidence.
Mr. Sullivan.
Judge, all of the video in this case has been provided. There were multiple FHP dash cam videos provided, not just.
Why just FHP? When Bay County was the leading.
Let me finish my answer. I will answer that question.
You did cut me off.
Listen.
So, Mr. McCoy requested the SID body cams. We reached out to SID. They did not have body cams at that time. We asked for any dash cams that were potentially used. There were undercover vehicles. There were no dash cams for the Bay County Sheriff's Office. All the video that was involved in this case has been provided to Mr. McCoy. We've been over this 4 or 5 times.
Right, motion denied. Anything else, Mr. McCoy?
Yes, I got a motion to dismiss for spoliation of evidence that I would like to be heard.
Okay. I'm not going to hear it today, but you can file it and.
It's already been filed, Mr. Clark.
Motion to destroy evidence?
Motion to dismiss for spoliation of evidence.
We've essentially argued this every time we've had this
Yeah.
hearing, so I'm prepared to move forward if you.
Okay.
I'm gonna deny it. I'm gonna give you a written order prior to October 6th.
Okay, I got more things that I need to
What
address
else?
for the
What
record,
else?
because this is based on this trial.
What else?
So now I'm asking you, Mr. Clark, you don't believe that's prejudicing me by denying me this evidence? You don't believe
I don't
that?
have that. If I had the evidence, it was up to me to
It
have the
was,
evidence.
it
I'd
was
give it
there
to you.
when
but
it
I
was
don't
available
have it.
when I was requesting it. You
That's
denied
what you're arguing. I'm gonna cut you off because we've already had this argument before. Anything else
What-
new?
how-
Anything else new?
Yes. How can you?
Okay, I'm not. gonna-
It's not. I'm
Motion
not
denied.
asking.
That concludes the hearing. We'll see you.
I'm not
October
done
6th.
talking, Mr. Clark.
We'll see you.
I'm talking. I'm trying to prepare for my trial. I'm trying to present. I'm trying to obtain
October
evidence.
6th at 8:30.
Okay, what about my motion for this private investigator? All right, I'm telling
Have you filed that paperwork?
you. Motion to, yes, it's right here. I have it right here. The
Have you
motion-
filed it?
It's right here. Yes, you already responded to it. But you didn't respond to it. You didn't appoint my private investigator.
No, you have to. That's the problem with you representing yourself.
No, I did everything properly.
You
Everything's
have
been
to,
done.
you have
Only thing
to,
the court has to
listen,
do is
you have
appoint her
to-
to
you
my
have-
case.
you have to notice JAC.
It's done. They're waiting
Where?
on the court's response. Really can't expect me to go to trial by denying me my sculptory evidence either, Mr. Trial. Mr. Clark, that's prejudicing me being biased.
Okay.
Deny me all my rights as a pro se litigant and as a U.S. citizen.
All right. We'll see you October 6th.
And it's going to be a mistrial.
Okay.
And deny me all my evidence and force me to trial.
October 6th. You have to be able, if you're going to represent
I
yourself.
filed all the proper
Mister,
motions.
do you ever see the
denied.
lawyers arguing with me like that? No, sir. Whether I'm
It
right,
doesn't
whether they
matter.
think I'm right or wrong, they don't argue with me. So that concludes the hearing.
Look at everything you already
Remove Mr.
done to me.
McCoy
though.
from the courtroom.
Come on, man. Don't fucking. Hey, man, I'm trying to help
Mr.
you.
McCoy,
Hey, man, you need to stop that shit.
Mr.
you doing.
McCoy, you're getting real close to not being able to represent yourself because you can't do it competently. That's enough. All right, Mr. McCoy, bring him back. I don't need you to say a word, but I am going to tell you, any more outbursts last night, you will not be able to represent yourself again. You understand? Take him out.
Trying to defend myself.
All right, Mr. McCoy, I'm appointing the Office of Public Defender to represent you. I'm gonna find that you are not competent to represent yourself. We're leaving on October 6th.
Don't treat me like that.
Who's next?
Not a chance. And honestly, I have to give credit where it's due. The judge here made a brilliantly calculated move. The way I see it, this defendant deliberately pushed the boundaries of self-representation. It's almost as if he wanted a lawyer all along, but felt the need to put on a show first. So, he kept pushing the judge's buttons until he lost the right to represent himself, and ended up with exactly what he probably wanted from the start. In everyday life, we'd call that a roundabout way of getting the outcome you were after. That's a wrap for today. If you found this...
What we just witnessed is a powerful reminder of how quickly things can unravel in a courtroom. In the first case, a plea deal that could have meant probation instead collapses under the weight of a serious criminal history, and ultimately, the defendant's own courtroom behavior makes things even worse, leading to a higher bond and a much tougher road ahead. Then we shift to Mr. McCoy's case, where self-representation becomes a double-edged sword. While it's a constitutional right, it comes with serious responsibilities, and as we saw, pushing back against the court without proper legal grounding can backfire fast. In the end, the judge steps in and removes that right entirely, appointing a public defender to ensure the case proceeds properly. These hearings highlight a critical truth: courtroom strategy, behavior, and credibility matter just as much as the facts of the case. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.